Hello. My name is Stephanie Whiteside, and I am Senior Staff Consultant for Professional Standards and Practices. I am probably not the person most teachers want to meet because of the very nature of what I do. But today I'm going to walk you briefly through professional standards and practices. I will be at one of the tables after the presentation. Just want to talk a little bit about it, kind of give you an understanding of the background checks and the convictions that could possibly impact an educator's certificate. And when we talk about educators, we're talking about any certificates that are issued by the Michigan Department of Education and state board approvals. As you are aware, the K-12 employees undergo fingerprinting as part of a criminal history check, which is a condition of employment. The legislation does allow for sharing of the results between K-12 schools. That being said, if a district does not wish to share, or they say they can't find them, or the dog ate them, then that applicant has to undergo fingerprinting, okay? As you know, back in January 2006, all employees had to undergo fingerprinting, and they have continued as you hire in new employees, they must also undergo the fingerprinting. There will be districts that will not share because the last printing was done in 2007. That's up to them. They are not mandated to share. It says they can. And I know you will get some applicants that will tell you that they have the highest clearance in the world, that they are just under President Obama, that they are the right hand of the superintendent, and all of that is wonderful that you have allowed them, you know, they want to teach at your school, they still have to undergo fingerprinting. And the reason is because you are indexed as a school employee, which means that if a school employee is arrested, they are processed, it will roll back to the department that that individual has been arrested. Okay. Your volunteers, we often get that question. Volunteers are not fingerprinted under the school employee index. They are under a volunteer, I believe it's through CPS, and we do not get a rat back on those individuals. If you have questions regarding your school employee index, or if the information, the person tells you it's incorrect, you would work directly, or that individual would work directly with the CJIC, the Criminal Justice Information Center, of the state police. Let's go a little further. If a school employee has been convicted of a listed offense, typically those offenses are ones that they have to sign on as a on the sex registry. If they are employed, well, first of all, if they're employed in your school, ta-da. But if for some reason they're still working there, you verify that information, and then they have to go. Bye-bye, have a good day. They are not allowed to work by law in any Michigan K-12 school in any capacity. Any capacity, okay? Just any capacity. We got that? Okay.
But if they're work with a private company in around the school, how does that fit?
Okay, that's a question that I said we're going to take after. So see me at the round table. See, that way y'all all show up at my round table. Okay, if they have a felony that is enumerated in the statute, which means it's listed in the statute. And the statute does say any felony. There has to be an agreement between the superintendent and the school board in writing in a public meeting to hire or continue to employ the individual. If one of those two parties does not agree, the individual does not have a job. Misdemeanors, schools have some flexibility, and it is going to be your school board policy. Now, that's for non-certificated individuals. If a certified administrator, teacher, school psychologist, if those individuals have a felony, they will be asked to join us in a compliance conference to determine the status of their certification. If the misdemeanor is enumerated in the statute, again, they will be sent a very friendly letter and asked to, pick up the phone when we call. We do get notifications, and we do act on them. It may not be something, because we work directly with the certificate holder, that we may not necessarily contact the district until we are finished. If there is action taken against a certificate, the district will receive notification. If the schools, meaning the central office, become aware that an employee has been convicted of a felony or an enumerated misdemeanor, they are required by law to contact the department. The arraignment is a 3 business days. If it is one that is enumerated in the statute. The statute to which we refer is MCL 380.1535A. It correlates with section 1535A of the revised school code. And this is the statute, talks about the suspension and or revocation of certificates. We, and this is all on PowerPoint, but basically we determine if there's an action to be taken, if it's actionable, is it one that we should summarily suspend for? And the third one is for state board approvals, but it does not involve substitute teaching permits. Let's back real quick with sub permits. When those are submitted to the department, you have to fax over court records. Otherwise, your permit application will sit. Okay. So just throwing that out there so you are aware. The turnaround time on those are relatively quickly, saying within 1 to 3 days clearing conviction review. However, if you notice that there's no action, it could be because we did not receive court records. Fast forward, one thing that comes up a lot is that the district told me that they will suspend my teaching certificate or revoke it. Tiger tidbit, the district didn't issue the certificate. The district cannot take it away. The district can take your job, but MDE has the authority to take action against a certificate. Most educators don't have a clue what they're supposed to do when they're driving down the street and they hear, woo! It's my own sound effect, isn't that cool? They don't know, because most educators, the first thing they will do is get an attorney but they get a criminal attorney. The criminal attorney, unless they are versed in administrative hearings and education, they sometimes will tell them, well, it's a misdemeanor. It really is not a big deal. And they go along in their mindset with that until they receive our letter. I strongly encourage the districts, I strongly encourage you to have the difficult conversation with your staff. Put it on your website. Most often, they don't know about 3 business days for arraignment. Most often, they being the educator, are not aware that they have a responsibility. And most employers don't put it in the new employee packet. They don't put it in the welcome back for the veterans packet. And it is something you should be sharing. In sharing that, you're hoping that none of your staff have to utilize it. But the fact that you have informed them of it is a great thing. The schools are required, and I'm sure if any of you work in personnel or human resources, you know you're required to obtain the disclosure of unprofessional conduct, and you know it's not often easy to get. Is that correct? So here's the tiger tidbit of the day. You send out the letter, and in the letter, you give a specific timeline for return. If you do not receive it back by that date, you send a second letter. All letters are sent delivery confirmation, not certified mail. Certified mail, they may not sign the card and you're still in limbo. Second letter, you send out and you inform them that we did not receive anything from you by this particular date. We are once again asking you to provide this information by this particular date. That date comes and it goes and you've heard nothing. You send one final letter. In that particular letter, you say, we have sent 2 previous letters and we have not heard anything. It is therefore our presumption that there is no unprofessional conduct. If there is something, if you need to respond to us, we would appreciate it. But however, if we don't hear anything from you, that will be our presumption. When you do that, put it in bold print. If there is something, trust me, you'll get a response, because now you're putting the onus on them. And if something jumps off, they're going to be on the front page because you're going to say, well, they never told us. And you have a paper trail. So that's my tiger tidbit for today. If you have any questions, feel free to contact me. You probably want to use email.